Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of Samfiru Tumarkin, dealing with all things related to disability claims, insurance claims, life insurance, and critical illness. So if you've got questions, please send them along to us via the social media platforms, or you can go to disabilityrights.ca to get further information. First question already, thank you. So the first question is from Yusuf. If the insured cannot find counsellors that speak my language or translator, and all assessments have done instructions, what could happen? So let's do it this way. If you are being seen by an insurance company's assessor, for example, if you had something called an independent medical examination that was performed, either by a psychiatrist or a psychologist, and you have difficulty speaking the language in which if you have difficulty getting somebody to speak your language, I would advise, I think, in this situation, that you request from the insurance company to provide an interpreter or a translator who could assist you, because obviously the insurance company is going to be relying on the opinion of the person who they retain to assess you. And in that instance, that person obviously has to understand what your concerns are. If you're speaking about a counselor, I'm assuming it is a mental health claim. So lots of mental health issues, or the way that they are dealt with at least, is in terms of self-reporting. So you will be reporting what your restrictions are, what your limitations are, and the difficulties that you continue to experience. And the assessor will then provide an assessment, a written report to the insurance company to advise the insurer what the diagnosis may be, what the restrictions and limitations are, and what, if any, difficulties you may have in order to perform the duties of your occupation and to return to work. And they may also make some treatment recommendations. All of that must be done in terms of a meeting with you where the person who assesses you understands what you're saying, of course. So insist that the insurance company funds an interpreter for you to attend the assessment if that is what we're discussing. I hope that helped. If you've got further questions, you're welcome to reach out to us. Again, you can go to disabilityrights.ca for more information. The next question is from Linda Bell. What if you have an injury claim and need to get LTD as well? What should you do first, or what is the best process? This is a great question because this often comes up. Also in the context if it is a workplace injury. So let's, for the moment, put aside that it may not be a workplace injury. So let's say you injured yourself and you now have a claim for personal injury. You may want to speak to a personal injury lawyer about that as well. But if you're eligible for insurance, in other words, for long-term disability benefits, you still have to go through the process of applying within the specific timelines. Each policy, so let's assume this is a group policy. Each group policy has specific timelines within which you must submit notice of claim, in other words, advise the insurer that a claim is forthcoming, and also provide proof of claim. Lots of policies do provide that if you are eligible for other sources of income, you have to apply for those, but more so in terms of a personal injury claim, that if you receive wage loss, or maybe even loss of earning capacity from the person or the entity or the insurance company of the person who caused you the harm, that your disability insurer may subrogate against that. What that means is if they paid you, let's say they paid you benefits for a year, let's say it's the year of 2024. You received long-term disability benefits for the year of 2024 from insurance company X, who is your disability insurer through your employment. Then you also have a claim against the person who caused you the injury. They may have insurance, and that insurance company may pay to you wage loss for the same period that you received long-term disability benefits. Your insurance company X will then likely want to recover the money that they paid to you. Otherwise, from their perspective, you will have received double compensation. So you should speak to a lawyer who deals with both disability and personal injury. And if you have a claim, you don't want to miss the timelines with respect to each of those. So I don't think wait on one and then do not do the other. make sure that you don't miss the timelines. And you're welcome to reach out to our firm, of course, if you've got further questions on that. There's another question on YouTube from Surfside. My insurance company pushed me into trying a different treatment. The new treatments have worsened my condition and caused a lot of pain. I spoke with my doctor and he agreed that stopping is best. Now my insurer is saying I am refusing treatment and have said they will be cutting me off. What can I do? Are they liable at all for the problems that this has caused? This is an interesting question. I recently dealt with a similar situation. Let's go back to basics. Each insurance policy is a contract. That contract has rights and obligations on both sides. Under the terms of the contract, there is, and there likely will be, a rehabilitation clause. And the insurance company will say that you are obligated to participate in a rehabilitation program that is appropriate for your condition. So that's your obligation. If you refuse, they will say that you are breaching your obligations under the terms of the policy. So based on what I've just said, it sounds very serious and sounds very concerning that if you don't do what they insist you do, they're going to terminate your benefits, which is to some degree what happened here. But obviously, sound minds must prevail. It has to be reasonable. If you are engaged in a treatment program with your treatment providers, and then the insurance company comes along and says, we want you to participate in a different type of treatment program with these providers whom we will pay, because there's no obligation on an insurance company pursuant to the disability policy to actually pay for treatment. The only time that they're going to do that, in my mind, is when it is in their interest to fund treatment, because it will likely, in their minds, get you back to work sooner, which means that they don't have to continue to pay you disability benefits. So if you participate in this treatment program, which you have done, Surfside, and that treatment program worsened your condition, that is very concerning. Obviously, it is not an appropriate treatment program for your condition. You did the right thing by speaking to your doctor, and that your doctor has now weighed in as well by saying that this program is not appropriate for you. It carries with it a risk that your condition will worsen because it already has worsened, and therefore is suggesting and recommending that you not participate in this program. Ultimately, the insurance company should have the same goal, that you improve so that you can get back to work. The goal should not be that you participate in a treatment program that worsens your condition or prolongs your disability. So even if they insisted, how is this going to benefit them? My position on this would be that I don't believe you did anything wrong here. If the insurance company has forced you to participate, you're saying you're no longer going to do so because it worsened your condition based on medical advice, which is always what I recommend. Get written advice, written opinions from your doctors to advise why the program is not reasonable and is not advisable for your specific condition. If the insurer then terminates the claim, I do believe you have a very strong case to pursue that and potentially pursue a claim for damages as well, because the insurer should not put you in harm's way. These are peace of mind contracts. So if that is what happened, please reach out to us so we can have a fulsome discussion with you to see what exactly the facts are here, what the circumstances are, and then we can discuss with you what your options are, and you can make an informed decision. And as I always say, you'll see it on the screen there. Go to disabilityrights.ca for more information. Okay, here's another question. In case you die from a terminal illness, are you entitled to receive some form of severance or your time for service? So that is an employment question. Fortunately, we do have a whole employment team at this firm who can respond to employment questions as well. Just for interest, tomorrow, Wednesday, which is October the 16th, as you can see on the screen at 1 p.m. Eastern Standard Time, we will have our employment law Q&A with my partner, Samfiru. So please pose your question to him at that time. I know often these questions overlap, but I think considering that we're speaking about a severance issue, it's the best way to proceed is to ask an employment lawyer. Another question from Yusuf, but this one is on YouTube. I'm currently on LTD for the last 24 months. I was recently terminated from my position after providing a doctor's note saying I will need another 6 months off. Will this impact my LTD payments? What should I do? So firstly, you should speak to an employment lawyer, considering that your employment has been terminated, and see whether there's a potential claim for severance. As it pertains to the long-term disability claim, I note that you have been off work or have been receiving LTD benefits for 24 months. Your policy likely, if this is a group policy and not an individual policy, if it is a group policy with a change of definition, which means that for the first 24 months, some policies have 12 months, others have 36 months, but basically all of them will have a own occupation period for 24 months. Then the insurance company assesses after that period whether you're unable to perform the duties of any other occupation based on your transferable skill sets. And within your medical restriction limitations, that would pay to you a certain percentage of your pre-disability income. So if the employer has terminated your employment, would that impact your entitlement to benefits? No, it should not. What the insurance company will do is continue to assess whether you remain disabled within the meaning of the policy. If the insurance company denied you, I don't believe it would be because of the employer's decision to terminate your employment. It would be because you no longer meet the definition of total disability with the insurance company's position. Doesn't mean that that's correct. If that were to happen, excuse me, again, reach out to our firm and we can discuss with you what your options will be. Lola Daniel says, hi, can I claim my former employer as the cause of my illness or disability after leaving employment from them? So I suppose this is a hybrid type of question. If you say that the employer is the cause of your illness or your disability, first thing that jumps out at me is that may be a WCB claim. Because if you suffer a disability as a result of a workplace injury, which includes mental health. So if you are bullied or harassed at work and you have a diagnosed psychiatric illness and it's solely related as a result of the workplace, bullying, harassment, or some other form of injury, then the claim lies with WCB. And in that case, if the claim lies with WCB, even if you pursue the claim against the insurance company, they will likely say, well, this is a WCB claim. We, pursuant to the terms of our policy, can deduct whatever WCB pays to you from what we have to pay to you. So to put it blunt, in clear terms, if your LTD benefit were to be $3,000 per month, which would be a percentage of your pre-disability income, and your disability is 100% related and as a result of the workplace injury, your claim is approved by WCB, they pay you $4,000 a month. The insurer will deduct that. Obviously, it basically wipes out your LTD benefit. Does that mean you should not still submit a claim to the insurance company? No, it does not. You should still do that because there will be certain timelines within which you have to do that. Every policy has notice of claim and proof of claim provisions. So for you, if it is a workplace injury, submit a claim to WCB because the insurance company will insist that you do that in any event. If there is a disability that resulted as a result of this, the workplace issues, you may want to pursue a claim against the insurance company as well, because if the insurer says, okay, we may approve this claim, but WCB is paying you, we're not going to pay you anything because we deduct that, what WCB pays. But what happens if WCB stops paying you? Then you want to make sure that you already submitted the claim, because I've seen many situations where it is a workplace injury. The person applies to WCB, does not submit a claim to the insurance company because the assumption is that WCB will continue to pay. At some point, WCB may deny the claim, but the person remains disabled. Then they submit a claim to the insurance company, and the insurance company denies the claim by saying, no, we're not going to pay this because you missed the notice of claim and proof of claim timelines. I've seen lots of these where people did not do that, sometimes because the employer suggested and recommended that they don't do it. So If it ever were to happen, or if this is the case with you, make sure that you submit it to both entities. Liminal Spaces says, I have been off work for a few months due to a mental health condition. My insurance has rejected my claims. I'm appealing for a second time. Is there anything I can do to make that successful? The first appeal was rejected due to something called lack of documentation. I sent along everything they asked for and more. You're welcome, Lana. So this is always the issue, what to do when your claim is denied. Do you appeal? What other options do you have? At our end, we pursue legal claims against insurance companies because it gives you leverage to negotiate with an insurer. With an appeal, there is no leverage because it's simply you asking the same entity who denied your claim to now approve it. In a situation where it is a mental health illness, you've already submitted the claim, you did an appeal. I just want to be clear about this. This is your second appeal. Yeah, second appeal. So the first appeal, you submitted all the evidence that you say you have. What that usually would be, if it is a mental health claim, if you are seeing your family physician, if you are seeing a psychologist, a counselor, or a therapist, or if hopefully you're seeing a psychiatrist as well, that would entail providing evidence from those treatment providers outlining what your diagnoses are in terms of your mental health and what the functional impairment is. In other words, what are your restrictions and your limitations? That's what an appeal looks like. It's not enough to say my patient has depression or anxiety, therefore they cannot work. Many people with depression and anxiety do work. So you're the person making the claim. So you have the duty, the onus to prove why it is that you are disabled within the meaning of the policy. The policy will provide that because of an illness or an injury, you are unable to perform the essential duties of your regular or your own occupation. So have your doctors consider what are the diagnoses, what are the restrictions and limitations, in other words, the functional impairment, which may be, if it's a mental health claim, it may be poor focus, poor memory, poor ability to multitask, poor sleep or oversleep, social anxiety, social withdrawal, physical manifestations of anxiety or panic attacks, cannot multitask, cannot meet deadlines, suicidal thoughts, whatever it may be. How does your illness impact your ability to function and work in your occupation? That's what is required. So the doctor may want to look at what are the occupational duties, speak about the functional impairment, and then conclude, if that is the doctor's position, why it is that you cannot work in your regular occupation. But it sounds like you've already done some of that. So if the insurance company has already dismissed your first appeal and you say you've already submitted everything that you have, I think it's time to speak to a lawyer. So reach out to us at disabilityrights.ca and we can discuss with you what other options you may have, which in most instances may include a legal claim. Sometimes we cannot assist in unionized cases where there is a mandated appeal process that the person has to follow. But we won't know. We would require further information. The consultations are free, by the way. So you can reach out to us, have a discussion with us, and then decide how you want to proceed. Okay, so next question is from Alexandra, and that's coming through YouTube. I'm currently off on short-term disability, but my doctors have said that there is no way I can return to work in the near future. I need to transition to LTD, long-term disability, but I'm worried about talking to my insurer and saying the wrong things. How should I approach this? What should I do before speaking to my insurer? My first point of advice, and it's always the same, is see your doctor regularly. Make sure that you report to your doctor your ongoing restrictions and limitations, your symptoms. If you're having a bad day, make sure that the doctor knows that the doctor completes that in the clinical chart. If you have a better day, put it into context. Why is it a better day? Compared to what? Yesterday you weren't able to get out of bed. Today you were able to get out of bed. Your condition waxes and wanes. Make sure that it is all put in context. See the doctor regularly on the basis that the doctor will have a clinical chart for every visit. So there's going to be a paper trail of all the times that you saw the doctor, of all the times and all the issues that you reported to the doctor. so that when you do transition to LTD, you have your doctor's support and that the doctor feels comfortable to provide an informed opinion as to your disability. If the doctor doesn't see you regularly, and then you go to the doctor and say, well, my condition is improving, I want to now transition to LTD, the doctor may not be entirely comfortable to support that. So it is very, very important that you see the doctor regularly, not just for that reason, but also because the policy requires you to be under the regular care of a physician. Also follow through with treatment advice. If you have been off work for a period of time, your condition isn't improving, you've been taking medications that for whatever reason have not worked or may have created side effects or might even have worsened your condition, tell that to the doctor. Consider whether there are other options for treatment, other medications to try. If it's a mental health illness, what about counseling? Seeing a registered psychologist or a counselor or other treatment providers. If things are not getting better, have the doctor consider whether you should be referred to a psychiatrist or a specialist, depending on your illness. These are things that are all important. Should you be scared or afraid to have your claim transition to LTD and to tell the insurance company that? I don't think so, as long as you've done everything that I've just said. Because when it gets to that time, number one, you don't want to miss the timeline. It is true in certain instances that the insurance company who adjudicates the short-term claim is not the same insurance company that adjudicates the long-term claim. If they're different, you don't want to miss the timelines. The insurance company, if it is the same one who adjudicates short-term and long-term, will know that the timeline for the short-term may be ending soon, and they may reach out to you to have a discussion as to what your restrictions, limitations are, what your treatment is, whether you've had any improvement, because they're aware that it will transition to LTD. So you want to be proactive, I think, and have discussion with the insurance company if your condition isn't improving and you have your doctor on board to ask the question, what happens? Because I know my claim is going to be ending in 2 weeks or 3 weeks. I've got my doctor's support that I can still not return to work. I'm following my doctor's advice. What should I do now? How does it transition to LTD? I think having that discussion is not a bad thing. But remember, focus. You always have to be honest, right? But you also want to make sure that you speak about the restrictions, limitations that you are experiencing. Insurance companies often conduct things that they would refer to as functional telephone interviews. And during those, they do ask people what it is that you do on a regular basis. What do you do in your average day life, your activities of daily living? All of those questions relate to getting information regarding your function. So it's very important that when you do speak to them, also speak to them about the things that you cannot do. If you've got further questions on that, by all means, reach out to us. You're welcome, Liminal Spaces. Another question from Gina S, and that came through Reddit. I will be separating from my partner, of course, my LTD payments to change. If I need to hire a support worker because I will be living alone, will I receive additional coverage for this? So let's speak about this in the context of a disability policy. What I understand this question to be is, if you separate from your partner, will that cause your LTD payments to change? It shouldn't. Long-term disability benefits are assessed based on a person's functional impairment, whether they can work or not based on their familial relationships or whether they're married or whether they're divorcing. That may have other impacts, but not an assessment of whether you're disabled or not. Your entitlements should remain in place. If you need to hire a support worker because you will be living alone, will you receive additional coverage for this? If we're speaking about a disability policy, and it's either through your work, in other words, you've got a group policy, or you've purchased an individual policy. The benefit amount itself usually is calculated based on a formula detailed in the policy. It's based on your pre-disability income. So it's a percentage of your pre-disability income, or there's a formula with staggering percentages to calculate what your LTD benefit would be. If it is a regular disability policy, that is your entitlement if you're disabled. There will be no other payments made in addition to that if you need to hire a support worker. Insurance companies sometimes may decide to make an additional payment in terms, let me rephrase that. They may make an additional payment with respect to funding of treatment. So if they feel that if they have you paid, if they pay for 3 months of treatment, which they believe will be leading to some recovery, which ultimately will lead to an earlier return to work, they may do a cost-benefit analysis, whether it's beneficial to them to pay that cost versus not paying it and having you be on disability for a much longer period of time. So it's financially viable to them and makes financially sense to them that in the long run is going to save them money. Then they may decide to fund treatment. I haven't seen cases where a support worker was funded, but I doubt whether that would be the case. But if you have got more questions, welcome to reach out to us, disabilityrights.ca, as you will see on the screen soon. And we can discuss with you, once we have further information, what your options are. Okay, do we have more time? Yeah, we've got a few more minutes. So ST-Bean2 says, to what extent can an insurance company place you under surveillance? Is it normal that they do this? My sister says it's happening to her and is worried. If the person suffers from schizophrenia, are they allowed to do something like this? It could make things worse. It's always a difficult situation to be in. If the insurance company is conducting surveillance, let's look at it from a legal standpoint. Are they allowed to conduct surveillance? Yes, but with everything, of course, there are parameters. They cannot hack your emails or listen to your phone calls or into your house. Can they follow you around? They do. The one thing that is very, very, very beneficial to them, I suppose, these days would be social media. What are a person's activities on social media? Because it's like a gold mine. If you're very active on the internet, on social media, they can access that, and they do, through investigators, to see what you're reporting through social media, what you're presenting, whether that is consistent with what's actually happening, or whether that's consistent with what you've reported to them in terms of your restrictions and limitations. So can they follow you around? I've seen lots and lots of surveillance videos where insurance companies hire an investigator and they follow the person around. Like they leave their house in a car, they may follow them, they may go to Tim Hortons or go to the hardware store or drop their children off at school and pick them up again and drive home. They may sit outside the person's house. They do this. Do they do it regularly? I think they do it in fewer cases than in ones where they don't do it. So, or rather, the chances of them doing it, it depends on the claim itself, of course. What is the benefit amount? How long has the person been off claim? Sometimes people make anonymous tips that may lead to surveillance as well. If there is a diagnosis of schizophrenia, and it may worsen the case, the situation, the condition, the only thing that I can think of is have a doctor weigh in on this. Because it may not be that the surveillance is being done, but reporting it to the doctor is not a bad idea as well. And that may be reflected in the clinical records. If your sister feels that she is feeling unsafe, if she's driving, there is somebody following her around, she may want to report that to the authorities as well. But the main question is, are they allowed to conduct surveillance? Yes, but within parameters. Okay, so we've got 1 minute. I've got a question from Richard Willemse. I was on LTD and returned to work after 23 months. Okay, so that's just before the change of definition. Just over 2 months after returning to work, I was diagnosed with a new health issue. I'm on LTD again, but they are paying significantly less than before. My last day of earnings was 2019. Salary and commissions. Temporary shutdown for COVID, returned to work, then broke my hip. All for 24 months, returned for 2 months. Not quite sure why they would be paying you less than before. Your policy will have a recurrence provision, but what I'm understanding from this is that you are off on LTD for an entirely different condition, unless it is that the insurance company looked at your income timeline that you did return to work. So they're looking at this as a new claim. Did you return to work full-time hours? I think there's an argument to be made that it has to be done based on your pre-disability income. But if you return to work full-time, And this is not a recurrence. It depends on what the language in your policy says with respect to the earnings. You'll see there will be a definition for earnings in the policy, and the benefit amount is always calculated on the lower of what the benefit formula is and on what premiums the employer paid. Excuse me. But Richard, I think for you, we may need to have a discussion with you to just understand exactly what was happening before, what is happening now, understand the issue, but we need more facts to give you an informed opinion. So you're welcome to reach out to us at disabilityrights.ca. With all of that, thank you for tuning in. That was a very fruitful discussion, lots of questions. I welcome those. Thank you so much. Our next session will be tomorrow. That's an employment law Q&A, and that is with Samfiru, 1 p.m. Eastern Standard Time. So that's 4 p.m. Pacific Standard Time, and it's on Wednesday, October the 16th. Thank you, everyone, and I look forward to having another session in a few weeks. Have a good day.